Hello, I'm Alan Gassman. The 10-minute webinar that you are about to see was recorded live for use by our clients and professional advisors. You can view the second part of this webinar at no charge by going to our website at gassmanlaw.com and clicking on the webinar library page. Or you can just Google Alan Gassman webinar and it will come up for you. You will also see a great many other free webinars that we hope will be of help. We welcome any and all questions, comments, or suggestions for these presentations. You can also download the PowerPoint you are about to see from our website in the webinar library page. Please feel free to share this with your colleagues, family, friends, and advisors. I can be reached at agassman, A-G-A-S-S-M-A-N, at gassmanpa.com. Thank you.
Upcoming webinars and seminars. On next Monday, September 12th, so that's a week from Monday, we're going to be giving a webinar with Chuck Wasson on insurance gaps and how to make sure that you don't have dangerous gaps in your insurances. September 19th, and I'll be speaking to the Tampa Bay Medical Manager Association Thursday, September 13th, on keeping medical practices independent. Page 4, our present webinars that you can find on our website to view at no charge are partially listed there. Page 5, our book with BNA. We donated 30 copies to the Clearwater Bar Association. You can buy one for $45. They're normally $55. Citations, if you want to learn more about the law, we have a lot of citations for you there. Leaving myself with 12 minutes now to cover the topic. So, page 7, the big news is that for powers of attorney executed on or after October 1, 2011, these will still be good. There won't be any changes needed. And also, if a power of attorney is at that state, then that's going to be fine. There will be no changes needed. But if you have a power of attorney executed on or after October 1st, 2011, you have to be very, very careful. We're going to repeat everything I say a couple of times here, but the main news is any power of attorney executed on or after October 1, 2011 in the state of Florida is probably going to have some big problems if you don't. The other big news is that if you appoint someone who is not your heir or a lawyer or a Florida licensed lawyer or CPA or a trust company, if you appoint just somebody else and they have at any time in their lifetime served 2 other principals, then they are not allowed to charge for the service. If they charge for the service, then what they do for you is illegal and may not be. Now I'm going to go to page 9 now, and I'm going to learn by experience. We have 9 catastrophes that can happen as a result of the new Florida Durable Power of Attorney Act. The first one, which I'm going to mention later, is that a springing power of attorney will not work at all if it's signed after September 30, 2011. If I sign a power of attorney which says, I appoint Christopher DiNicolo to be my capacity, and I sign that after September 30, 2011, then that power of attorney will have no force or effect whatsoever. Now, there's a question if I sign that power of attorney pursuant to Delaware law while I'm in Delaware, whether it might work, and the answer is it probably won't work, and it's not worth trying. Now, the next big change is that my power of attorney would typically say, I authorize that I by law could do for myself, and that would work under present Florida law. But after September 30, 2011, I have to initial or sign next to any provision that would allow him to, A, create a trust for my benefit, B, amend, revoke, or terminate a trust that I have prepared, C, at the end. As a matter of fact, Chris is going to give you a 5 to 10 minute bonus session on gifting And that's how I'm going to finish in 15 minutes. Anyway, D, change rights of survivorship. If you don't have this in the power of attorney, the agent will not be able to change rights of survivorship. Next, create or change a beneficiary designation. Next, waive the principal's right to the beneficiary to be in the power of attorney document. You have to have the client sign it and initial it. Next, disclaim property or powers of attorney. So those are very important things that every power of attorney is going to have to provide for. And you're going to have to go through these with the client to see if the client wants to give each of these powers. And that's going to take more time in the conference room, more time drafting, more time explaining, and the banking industry getting into the agent under power of attorney business and being very cautious for their welfare in this legislation. Now also, when you execute a power of attorney after September 30, 2011, if you don't have 2 witnesses and a notary to each principal's signature, you do not have a valid power of attorney. Now that's witnessing and notarizing the signature of the principal. That's the person who's witnessed and notarized power, or have always witnessed and notarized powers of attorney, because under the Equal Dignities Law, an agent under a power of attorney can't sign a deed and can't do certain other things unless the power of attorney has 2 witnesses and a notary. But it can't hurt to update your power of attorney and to have 2 witnesses and a notary. Now, please note that healthcare powers of attorney under Florida law require giving the power. That does not apply to the financial power of attorney law, but it's just something that people will confuse, I'm sure. Also, as many of you are aware, in something called a self-proving will, you need 2 witnesses and a separate notary who's not a witness. That is not required under the power of attorney statute. Also, the next catastrophe, it would be that you would be appointed and you aren't a licensed Florida resident or CPA. I mean, you're not a licensed, and you're doing this for more than 3 people. You can't be paid for doing it. And then what you're doing, if you do it and you are getting paid, might be an illegal act. And you don't want to violate the Florida statutes there. And then the last catastrophe, I think we'll all see a lot of these, is the newspapers will have articles about the new power of attorney statute, and people who want to take advantage of other people will find folks who maybe have some wealth and are not that, and get them to sign powers of attorney and then steal from them. So if you're a lawyer or your accountant, certainly when somebody comes in and says, I'm bringing Aunt Matilda in and she needs to sign a power of attorney, but we're in a real hurry, so we only have a couple of minutes. You need to kind of sit back and think through, number 1, am I representing the agent or am I representing Aunt Matilda? And number 2, if I'm going to witness this, how am I going to make sure that Aunt Matilda has no assets and the person took them all? Where am I going to be as the advisor who set that up? Now, page 10, we have some basic information on powers of attorney. I think everyone watching this webinar probably knows what these definitions are. You know that a power of attorney terminates when a principal dies. Now, when you file here's part of the new law, page 11. If you file for a divorce, then and I think that if you then terminate the divorce action, you probably have to sign a new power of attorney. So there may be some people out there who will have disabled powers of attorney because they filed for a divorce and made up and didn't execute a new power of attorney. Page 12, if you initiate a judicial proceeding to prove someone incapacitated, then the powers statute, so during the pendency of a guardianship proceeding, the judge could order the power of attorney to be effective. Now, page 15, there's something called a military power of attorney. And I'm sure if you sign up for the military, it's probably one of the many benefits you receive as a military lawyer to provide you with a military power of attorney. And that power of attorney can spring, but it's subject to a lot of limitations. If you have a client in the military, they're serving our country, give them a discount, give them a new Florida power of attorney, and as opposed to trying to spring because of the military power of attorney limitations, I would consider an escrowed power of attorney. And that brings us to page 16. Now, I cannot sign a power of attorney that says that I give Christy Nicolo the power to sign documents for me in the event of my incapacity, but I can sign a power of...
The remainder of this webinar can be viewed at our website at gassmanlaw.com at the webinar library. Or you can just search Alan Gassman webinar and our library page should come up. Please feel free to share this with colleagues, family, friends, and advisors. And have a great day.